Yeah, people are already filtering in. All right, good afternoon, everybody. I want to thank you for joining us here today. My name is Daniel O'Neill. I am chair of the CLE committee for the Houston Young Lawyers Foundation. Welcome. Thanks for joining us here. This is the inaugural CLE of the bar year. We have a very impressive slate of speakers, and we are starting off with a fantastic person, fantastic lawyer. We're overjoyed to have Rick Houghton presenting our very first CLE of the bar year. So let me introduce Rick to the crowd for those of you who don't know him very well. He is a partner at Murphy, Ball, Stratton, a litigation boutique headquartered here in Houston. He is an Eagle Scout. He completed undergraduate at West Point. He served as a United States Army officer for 6 years, including as a commander of an air defense artillery training battery at Fort Sill, Oklahoma. He was awarded the Elder Endowed Rotary Ambassadorial Scholarship to the University of Oxford, where he completed a Master of Studies in History. He received his law degree from Harvard. He served as law clerk to the Honorable Lee Rosenthal in the Southern District of Texas, as well as the Honorable Greg Costa on the Fifth Circuit. He is listed in the Ones to Watch by Best Lawyers in Commercial Litigation. Rick is not only a brilliant lawyer, but he's also known for his kindness of spirit and generosity. He is incredibly supportive of everyone around him in the community, and he's always volunteering somewhere or another, including setting up numerous legal services clinics for veterans in need. I've known him for over 5 years, and we've served on various nonprofit boards together, so I can tell you we're all going to be voting for Rick as president of the United States one day. But for today, he's here to talk to us about the brand new Texas business courts. Rick, please take it away. And for the audience, if y'all have any questions, please just save them for the end. Rick is going to present, and then we'll have a Q&A session at the very end. So thanks again for joining us, Rick.
It is my pleasure to be here today. And I want to say thank you to, of course, Daniel, also Lucy Kane, who set this all up, and to Samantha Ann and all of HYLF for the opportunity to be here today. A lot to talk about because Texas has new business courts that we all may be practicing in soon. Indeed, some of you may have a matter before the court now. And what I hope to do is give you a brief overview of the new court, including important issues like jurisdiction, removal, some of the new rules governing the court's procedures, and the like. So with that, here's what I'll be talking about this hour. A quick history of how the court came into existence, its organization, its judges, jurisdiction, removal, remand, some new rules, fees, and the new appellate court that will hear all business court appeals. Perhaps unsurprisingly, Delaware was the first state with a business court, the Court of Chancery, which was established in the 1790s. Delaware's dominance in corporate law and corporate jurisprudence shows. Last year, almost 300,000 entities were formed there. Over 2/3 of Fortune 500 companies retained Delaware citizenship, and about 80% of US initial public offerings in 2023 were registered in Delaware. Perhaps trying to get in on the action, states around the country started establishing business courts with some frequency in the 1990s. Today, half the states have business courts, though they differ in many ways. For example, in Texas, parties do not need to consent to litigate in the business court if the court has original jurisdiction. But in some states, among others, Wyoming and Georgia, parties must all agree to have their case heard in the business court. Some states, like California and Delaware, have no amount in controversy requirement, but you'll see in Texas, that requirement will be a jurisdictional bar to many, many cases. A little late to the party, Texas joined these other states last year by enacting House Bill 19, which created the state's first business court. The governor signed the bill into law in June 2023. and the legislative history makes clear why the state decided to have certain business disputes resolved by a specialized court. And that's to enhance the business-friendly climate here and to encourage businesses to incorporate in the state. According to the bill's sponsor statement of intent, House Bill 19 was intended to streamline resolutions of business disputes and ensure the court is staffed by qualified and skilled judges, ideally giving businesses confidence in Texas's legal system and encouraging them to incorporate and headquarter in Texas. Shortly after enacting House Bill 19, the legislature passed Senate Bill 1045 and established the 15th Court of Appeals, the court that has exclusive jurisdiction over all business court appellate matters. For your reference, the codification of HB 19, which has the provisions governing the business court, is Chapter 25A of the Texas Government Code. So when you're looking to file in the business court, or when you otherwise just need to know the exact statutory language governing it, that's where you want to go. Unlike Texas's many trial courts, the business court is a statewide tribunal with one judicial district that has 11 geographical divisions that mirror the state's current administrative judicial regions. And that's shown here on this slide. But only the divisions that are highlighted in blue are currently operational. And those are, perhaps unsurprisingly, where Texas's largest cities are located. That's Houston, Dallas, San Antonio, Austin, and Fort Worth. We'll talk about venue shortly, but the rub of the limited coverage is this. If venue lies only in a county where a business court isn't operational, the dispute cannot be heard in the business court, even if the case meets the court's jurisdictional requirements. So we have coverage in our densely populated areas where the lion's share of economic activity is, but still a lot of the state, at least geographically is concerned, isn't covered. Now, the uncovered areas of the state may come online, but the legislature has to authorize the divisions there next year. And if it does, the authorized divisions in white can begin operating in September 2026. So it's TBD on whether Midland, El Paso, the Rio Grande Valley, and other areas of the state will be able to tap into this system. Let's talk about the judges who will hear cases in the 5 operational divisions of the business court, starting with their required qualifications. HB 19 provides that business court judges must be at least 35 years old. They must be a U.S. citizen. They must have been a resident of a county within the division in which they will serve for at least 5 years, so a 5-year residency requirement. And they must have 10 or more years of experience in complex business litigation, business transactions, or serving as a civil judge. And for that 10 years, you can combine those 3 experiences. The judges are appointed by the governor with the advice and consent of the Texas Senate. Sound familiar? And they serve 2-year terms and can be reappointed at the expiration of their terms. The 2-year term is interesting. How many cases have you been involved in that have lasted more than 2 years? I, for one, haven't been practicing for that long, but many cases I've worked on have lasted a lot longer than that. So while I assume these judges will be reappointed to consecutive terms, there is a chance you may have a new judge midway through litigation, just something to keep in mind. And as a point of contrast, state district judges serve 4-year, not 2-year terms. Note that we'll have 2 judges in the populated areas shown here in blue, and only 1 judge in the divisions shown in white. Here are our current business court judges. The governor appointed them just a few months ago. And if the legislature authorizes the 6 other divisions to come online, the governor will have the opportunity to appoint 6 new judges, which would bring a total of 16 business court judges in the state. For those of you who aren't familiar with them, let's discuss the background of our two Houston Business Court judges. Like many of us, well, at least me, neither of them are from Houston. Judge Sofia Andrade hails from Argentina, but attended college at Rice and law school at the UH Law Center. She clerked for the Fifth Circuit and has had a 30-plus year career as a commercial litigator, first at Sussman Godfrey, and for the past several years at Diamond McCarthy. Judge Andrade has been the editor of Texas Business Litigation Treatise and has presented on and written about Texas business law hundreds of times. And if that wasn't enough, she's served on 15 boards, including the City of Houston Mayor's Hispanic Advisory Board. For Judge Grant Dorfman, this is his third stint as a Texas judge. He is originally from Dallas, but his two other times serving as a jurist here were in Houston, first for the 129th District Court from 2002 to 2008, and second for the 334th District Court from 2013 to 2017. Judge Dorfman just completed additional public service as the state's Deputy First Assistant Attorney General, and before that, Judge Dorfman has practiced law as the head of litigation for Neighbors Industries and as a litigator at Sussman Godfrey and Ogden, Gibson, White. He's a graduate of Brown and Yale, and he clerked here in Houston for Fifth Circuit Judge Jerry Smith. Judge Andrade and Judge Dorfman's backgrounds speak for themselves, and it seems obvious that the governor was seeking to choose exceptionally qualified people to serve in the court. So what can judges Andrade, Dorfman, and the others do? Everything a district judge can. That is, award monetary damages, as well as issue declaratory and injunctive relief. So how do we actually get in and out of the business court? That's what I'm going to talk about in the next several slides. And what I want you to take away from this presentation is this. If you want to get into the business court, you can file a case there or you can remove a case there. And if you want to get out of the business court, you can move to dismiss for lack of jurisdiction, you can move to transfer venue, and you can move to remand the case out of the court. Of course, you can maintain a case in the business court, whether you file it there or you remove it there, only if subject matter jurisdiction exists. Just an initial point on jurisdiction, it's concurrent with the Texas district courts. So even though a case may be litigated in the business courts, that same exact case can still be litigated before a district judge. And with that said, there are two general avenues of jurisdiction into the business courts. They both require a significant amount of money to be in dispute, plus something else. So money, and let's call it a plus factor. The first avenue to the court is more than $5 million in controversy and at least one of the bullets on this slide. That is a derivative action, internal corporate affairs, a securities or antitrust claim, a claim alleging a violation of a fiduciary duty, a veil piercing allegation, or a claim arising under the Texas Business Organizations Code. Amount in controversy isn't defined, so I assume the court will make law on that issue or look to how federal courts define the term with respect to diversity jurisdiction. And we'll have to wait and see whether a party will be able to aggregate claims to meet the amount in controversy requirement, like in federal court. Now, for this jurisdictional avenue, the amount in controversy requirement is waived if a party to the case is a publicly traded company. And that's a defined term in the statute that means an entity whose voting equity securities are listed on a national securities exchange registered with the SEC, as well as any entity that is majority owned or controlled by such an entity. So there may be a significant number of companies that are exempt from the $5 million amount in controversy requirement, which may in turn expand the court's docket in the coming months and years. The second main avenue into the business court is an amount in controversy that exceeds $10 million. Again, however, the $10 million jurisdictional avenue requires another ingredient, specifically one of the following: a qualified transaction that the statute defines as a transaction in which a person does or must pay, receive, lend, or borrow at least $10 million. Bank loans do not count and are excluded from the definition. Second, a commercial transaction in which the parties agreed in their contract or in a follow-on contract that they would litigate any disputes in the business court, though claims arising from insurance contracts do not fall within this plus factor. And lastly, a cause of action that an entity or a person acting on the entity's behalf violated the finance code or the business and commerce code. So not as restrictive here, especially when a qualified transaction can encompass a broad swath of complex business dealings. Think asset and purchase transactions, large service contracts, and many, many more. As we talked about earlier, the court has the same power that a district court has. So it can issue equity relief like declaratory judgments and injunctions. But the court only has equity jurisdiction over cases that meet the basic subject matter requirements. That is the $5 million or publicly traded company avenue or the $10 million avenue. So if you want to seek equity relief in the business court, make sure your case satisfies those requirements before filing. There is another way of having a claim heard in the business court, and that's through the court's supplemental jurisdiction. By exercising it, the court consider far more than just the claims that fall within its original jurisdiction. But what claims exactly? Per the statute, the court can entertain, quote, any other claim related to a case or controversy within the court's jurisdiction that forms part of the same case or controversy. Now that's a mouthful, but it sounds like another dispute from the same facts as a case that falls within the court's original jurisdiction. And to me, that sounds like a lot like the federal court supplemental jurisdiction test that courts apply under 28 USC 1367, the Gibbs test. But we'll have to wait and see how the business court, the 15th Court of Appeals, and the Texas Supreme Court define the statute and whether it will be the same or different than the federal court standard. Even assuming some similarities here, there is a sharp contrast than what you're used to seeing in federal practice. And that is, the court can exercise supplemental jurisdiction only if the parties agree that the related claim should be litigated in the business court. So if any party or even the court disagrees, the claim has to be brought in the district court or county court of law. That's going to be problematic, at least in my view, because of the likelihood of piecemeal litigation, something that courts and parties generally disfavor, not only because of the inefficiencies and increased costs, but you can also imagine collateral estoppel issues that may arise and frustrate a business court litigant, issues that wouldn't have happened or come up if the claims arising from the facts underlying the dispute in the business court were all litigated in the business court instead of in two different forums. Only time will tell whether and with what frequency parties will litigate supplemental claims in this forum, and whether this provision will change in the event there's a lot of piecemeal litigation. The court may exercise only supplemental and not original jurisdiction over these claims on this slide. So they're explicitly excluded from being heard in the business court unless they are related controversy and unless the parties in the court agree to bring the claims there. Those include, interestingly, non-compete disputes, DTPA claims, claims involving liens on real and personal property, and claims that logically seem to fall outside the business court's purview, like family law and estate law claims. One last point on the court's jurisdictional reach. The statute makes clear that the business court is prohibited from exercising jurisdiction, whether original or supplemental, over medical malpractice claims, personal injury claims, or legal malpractice claims. So a hard stop on those claims means that we'll continue to litigate them in the district court for the foreseeable future. That brings us to pleading, jurisdiction, and venue. New Texas Rule of Civil Procedure 354 governs jurisdiction and venue in cases that were originally filed in the business court. Under the rule, a party must plead facts to show jurisdiction and venue in a county that lies in an operating business court division. A party can challenge venue by following the well-trodden path of Rule 86, that is, filed in or at the same time as the first responsive pleading. If venue is improper, meaning the division's geographic area does not cover a county of proper venue, the court must transfer the case to another business court division if it would encompass a county with venue, or transfer it to a business court or county court at law that has venue. The venue issue may come up frequently because a large part of the state still doesn't have operating business courts. For jurisdiction, the court can sua sponte raise the issue, or a party may move to dismiss for lack of jurisdiction within 30 days of the party appearing in the suit. If the court decides on its own that jurisdiction does not exist, the court must give 10 days notice of its intent to transfer or dismiss the case and an opportunity for a party to object. If the court concludes there is no jurisdiction based on a party's motion, it can transfer the case to a district court or county court at law that is proper venue, or dismiss the case without prejudice. Because the business court has concurrent jurisdiction with the district courts, just like a federal court has concurrent jurisdiction over certain state law claims through diversity jurisdiction, a party can remove qualifying cases to the business court. The process differs from federal practice, however. For one thing, a party must file not one, but two notices of removal in both the business court and the court in which the case was originally filed. The notice must contain some of the basics that will be familiar to you. Most importantly, facts establishing that the case can be brought in the business court division where the notice is filed, meaning facts showing jurisdiction and venue. But a requirement that isn't mandated in federal court is whether the parties all agreed to removal. And that's because the deadlines differ based on whether removal was done by consent. If all parties agree to removal, it may happen at any time during the pendency of the action, so at any time before final judgment. But when it is not agreed, the removing party must file the required notices within 30 days after he or she discovered or should have discovered facts showing business court jurisdiction over the case. However, if a temporary injunction application is pending in the original court when the party knew or should have known of the business court's jurisdiction, the party may remove within 30 days of the TI application's resolution. So if a court needs time to resolve a TI application, a disputed removal can be delayed significantly. And keep in mind, in trade secret cases, that for non-compete issues, those don't fall within the court's original jurisdiction, but you'll have 30 days from the resolution of a TI application to remove a case to the business court. If there's removal, then you guessed it, there's a procedure for remand. And a party may move to remand a case back to its original court, but the party must do so within 30 days after removal. However, a party that is added to the case post-removal has 30 days to move for a remand after entering an appearance. And by my math, that will be the length of time to answer, so 20 days plus another 30 days after making your appearance, so at least 50 days. And like a federal court, a business court can remand on its own, but if it does, like in the jurisdictional context, the court must first give the parties 10 days notice of an intention to sua sponte remand in order to give the parties an opportunity to object. Let's talk about the new business court rules very quickly, just so you have an idea of what you'll face if you have a case in the business court sometime soon. Most critically, the Texas rules of civil procedure apply, and so do the Texas rules of evidence. And while there are business court specific rules now, and only a few, which I'll cover here shortly, practice in the business court will largely be the same as it is in the district court. And what rules governing whether there will be a bench or a jury trial? It's an interesting point, and the court has to hold a jury trial when a party would be entitled to one under the Texas Constitution. The plaintiff can select any county that would have venue for the actual jury trial. And that said, if the parties in the court all agree, they may choose to hold a jury trial in any county within the court's division boundaries. Okay, just some quick details on the business court specific rules that were just added to the Texas rules of civil procedure by the Texas Supreme Court in the last couple of weeks. Under Rule 354, the clerk must randomly assign a case if there is more than one judge in the division. So here in Houston, you won't know beforehand whether Judge Andrade or Judge Dorfman will be presiding over your case. Rule 354 also governs procedural aspects of jurisdiction and venue, but we already discussed those. And because we already discussed removal and remand, which are governed procedurally by Rule 355, I'll skip to Rule 356. It's quirky. It says that even if no party removes a case to the business court, by agreement or otherwise, a judge of a district court or county court at law may nevertheless ask that the lawsuit be transferred there. The court may do so by asking the presiding judge of the administrative judicial region in which the court sits to transfer the case. The requesting court has to notify the parties of the transfer request, and in the event any party objects, set a hearing in consultation with the regional presiding judge. The regional presiding judge is the decision authority. And all that is to say, know that a district or county court can move to transfer a case to the business court, even if the parties don't necessarily want to litigate there. Rule 357 provides that in the event the business court dismisses an action without prejudice, and the same action is brought in a different court within 60 days of the order of dismissal, then the applicable limitations period is told during the period between filings. Rule 358 is an interesting post-COVID rule, and it prohibits certain remote proceedings. First, the rule prohibits the court from requiring a party or advocate to appear electronically when oral testimony will be taken. Second, the rule prohibits the court from holding a remote jury trial, even if the parties agree to try the case to the jury remotely. Finally, Rule 360 says that the court must issue a written opinion in at least two circumstances. One, in connection with a dispositive ruling, but that requirement is triggered only if a party requests an opinion. And two, on an issue important to the jurisprudence of the state, and that's triggered even if no request for an opinion is made. The point of the rule to me seems obvious, and that's to begin developing a body of business court case law that maybe one day will rival a state like Delaware. Before we wrap up on the business court, let's get into some of the nitty-gritty that we'll be dealing with. First, if you want to communicate with or send, for example, documents to chambers, where are chambers? Under the statute, chambers will be in the county the judge selects within the geographic boundaries of the division to which the judge is appointed. In our division, probably here in Houston, but the statute makes clear that Judge Andragay and Judge Dorfman could have chambers in any one of the division's many counties. More importantly, where will court be held? Well, it seems like it'll be ad hoc, and that is anywhere that the court deems necessary and convenient. Again, I assume because of Harris County's facilities, there will be spaces to hold court and trials here in Houston, but there may be a need to hold court elsewhere. And if the business dispute is in another location, but within the division's boundaries, say Galveston or Montgomery County, court may be held there. We touched on remote hearing limitations, but those couple restrictions do not limit the court from otherwise holding proceedings electronically. And as far as filing goes, you'll use the same platform you do now, eFile Texas. And lastly, to the extent you need to contact the clerk's office or send things there, the clerk will be located in Austin, likely because the court is a statewide tribunal, like the 15th Court of Appeals. New court, new fees, and not just the couple $100 that the district court requires. The fee for filing in the new business court is $2,500, and that same fee applies to removal. Well, that's probably budget dust for the companies that will have matters before the court. Just know beforehand that the fee is multiples of what you're used to seeing now. Note also that any motion in the business court costs $50, and that is not an expense the parties pay in the district court now. I'll be very brief on the 15th Court of Appeals, but I do want to touch on it because some of you will likely argue appeals there in the coming months and years. Unlike the other 14 courts of appeals in the state, the 15th court will have statewide reach. It will not be confined to a certain geographic area in Texas. I'm talking about this new appellate court now because its jurisdiction includes all appeals from the business court. It also has exclusive intermediate appellate jurisdiction over a case challenging the validity or constitutionality of a state statute or rule, cases filed by or against the state and its subdivisions and agencies, though that grant of jurisdiction excludes some types of cases like personal injury and eminent domain. And the court can also hear mandamus proceedings within its original jurisdiction, like the other courts of appeals. On September 1st, all appeals that fell within the new court's jurisdiction were automatically transferred to its docket. Earlier this year, Dallas County challenged the upcoming transfer to an appeal it had regarding certain inmates. The Texas Supreme Court unanimously rejected the challenge in a published opinion. The court held that the legislature acted constitutionally in enacting Senate Bill 1045 and creating the 15th Court. And the Supreme Court further concluded that SB 1045 is constitutional even though the new court is specialized, has statewide reach, and has only narrow jurisdiction. In my mind, the Texas Supreme Court's decision signals that it would uphold the business courts, even if they are eventually challenged, as having been enacted unconstitutionally. So I consider these courts here to stay unless the legislature ends the experiment. And because of the court's ruling, the 15th Court opened as scheduled on September 1st, with certain appeals automatically populating its docket. The court's justices who will hear those appeals are Chief Justice Brister, formerly of the Texas Supreme Court, Justice April Ferris, who has been an appellate judge here in Houston and a former partner at Yetter Coleman, and Justice Scott Field from the Austin area. And he, like the other two, also has extensive judicial experience. That's all I have. And Daniel, I want to give any opportunity for questions. But I just want to say thank you again. Really honored to be here today with HYLF and to kick the CLE year off. And a special thank you to Daniel and Lucy Kane and Samantha Ann.
Fantastic presentation. Thank you. Okay, question and answers that have come in during the presentation so far. Request for CLE number. I am going to put that into the chat right now.
The most important one.
That's right. If anybody else has any questions, y'all can, I think you can, put your camera on, announce it, or if you feel more comfortable, just put it in the chat. We'll give you all a minute to start typing things up. I think of the most interesting things I've heard, that $50 on the motion filing fee. I think that would reduce a lot of our work in state and other courts if every motion cost $50.
And what I think is going to be the most problematic moving forward, and maybe I'll be wrong, is just this piecemeal litigation that the statute invites. I mean, complex disputes usually have and generate several claims, right? So if only 2 or 3 of those claims fall within the business court's jurisdiction and others don't, and the parties in the court don't agree to hear those other disputes, you're going to have piecemeal claims in at least 2 forums. And to me, that's just inefficient. That invites collateral estoppel and other preclusive issues. And I think will just be problematic, but I guess we'll just have to wait and see.
For law students who are on the group chat, if they're interested in trying to have a career doing these kind of cases, is there anything you'd recommend? Some reading, finding a mentor in the area. What might make them successful trying to break into this area?
That's a great question. I mean, just as far as reading up on it, Chapter 25A of the Texas Government Codes, it's short and sweet. I mean, that's the source. Whether you're a student, you're a practitioner, that's where you got to go. I think one way for students in particular, once, and I just haven't been able to find it, so maybe it's been announced and I missed it, but once judges Androgay and Dorfman identify, when and where they'll be holding court, I think it'll be fascinating just to watch these proceedings. Given the amount in controversy, I'd imagine there's going to be excellent lawyering. And I think just seeing the arguments and the live proceedings would be a great experience for a student.
And in terms of other practitioners who may do other other areas of litigation, but maybe want to move more towards this direction, would you recommend anything different for them to do? Versus what the law students might be doing. That's we get those kind of questions all the time, that these CLEs on fascinating topics, they're like, oh, I do family law or whatever it is, but now I want to do this.
I think just trying to, I mean, it could be moving firms. It could be trying to work with partners or colleagues at your current firm that have those kinds of matters. And I think I've seen announcements for these judges to hire briefing attorneys and things like that. But I think just the usual ways that you try to shift your practice. And I think really it might start with your firm. If your firm has some of this work, just working with people that do it.
Awesome. And okay, question on the chat now. Any word on local rules for the business court?
Not that I've seen. What I've just seen are the 6 rules that, and I'm trying to remember their number. I think it's 354 to 360 that the Texas Supreme Court just promulgated. I haven't seen any local rules by any one particular trial judge. What I did see, just going on the system, is I think there were 6. I think there were 6 matters that were pending already in the business courts as of yesterday. So parties, at least from what I saw, the parties know they're operational. They know that they have claims that fall within the jurisdictional scope and venue restrictions of the court, and they're filing cases there.
Are there any blogs out there, maybe something your firm has put together, any publications that might be required or at least recommended reading for people interested in going a little further with this?
Well, the Google was a real well of information for me, and what I mean by that is every firm essentially has published an article on these business courts because um, it could be the focus of significant litigation moving forward. So I think firms want clients and potential parties to know that they may be litigating there. So what you'll see with a quick Google search is there's just a lot of very helpful information that's easily digestible. So you can get some of the main points that I've given today in a quick article online. But none that come to mind that are really particular. I mean, the state, well, on the actual court's website, there's a memo. There is a memo that outlines some of the basics. I would actually, now that I'm thinking about it, I would recommend that memo because it goes into a little bit more detail than what the firm pages say, and I think that detail was helpful. So that's just Googling Texas business courts, the actual business court website, and then boom, the memo that's right there.
Excellent. And I will echo what one of our group chat people has said. Shout out to the Murphy Ball Stratton LinkedIn page and publications. Your firm does a very good job of posting stuff, and very interesting stuff, by the way, on LinkedIn. I get, so, like definitely, it's anybody who's interested in this kind of area may want to check that out first. A broader question though, who manages? Do y'all have like a social media person for that, or is that the lawyer saying this is what's interesting right now?
It is definitely not me. 99% of the credit for our LinkedIn content goes to my wonderful colleague, Michelle Stratton, who's an amazing lawyer and an amazing colleague. And yeah, she's been, in my view, just doing a great job getting our name out there because we just started on January 1st of this year.
Wow. And that the New Orleans case that I keep seeing posts on, that I'm very invested in that at this point. So, but that's subject of a different CLE you'll present.
Yes, yes, no, it's a fascinating case, and yeah, I'd love to talk about it.
Definitely. Well, we will have you back once there's some kind of resolution and you're allowed to talk about that. We are looking forward to that.
Well, I don't want to cut anything off, but my contact info, at least our website that has my contact info, is on the slide. If y'all have any questions about anything that came up today, please don't hesitate to reach out. And look, I know everybody's busy. I'm really grateful that Daniel, for you, to Samantha Ann, to Lucy Kane, and to everybody else that joined. I hope it was informative, and looking forward to being with you all sometime soon.
Definitely. And yeah, a huge thank you to you for spending all the time to get this presentation together and joining us here today. If you remember one last question from the group chat, then we can let everybody go.
Please.
Those 6 pending cases, were you able to find those on the research TX function?
I think that's where I looked. I think that's exactly where I looked. And I think it happened, in the last, for sure, couple weeks, if not a couple of days, but for courts in the dropdown, you'll now see Texas Business Court Division 1, Division 2, you'll see those, and you can select those to then see pending cases.
Awesome. So yeah, that answered everything that's in the chat. Nobody has turned their camera on to announce any. So we're at 12:47. We're past it. We needed to get past the 46-minute mark. So we've done everything we needed to do for compliance now. Yeah, unless anybody has anything else, I think I'll just say thank you again. This was an amazing inaugural CLE to kick off the bar year for us. For anybody who's still online, our next CLE coming out of the HYLF CLE committee, it's going to be December 18th. That's being presented by Robert C. That is family law for non-family lawyers. It's going to be very interesting to hear just about, if you're interested in taking a pro bono family law case through the use of volunteer lawyers, or you get a lot of, hey, my brother-in-law is going through this at cocktail parties. This is probably a good CLE to check out. So we know some basic divorce stuff to walk around town with. So thank you all again. Hope you all have a great rest of the day, and hopefully we see you on December 18th.
Hey, thank you so much, Daniel.
Awesome. So I will attempt to end the webinar. All right. Thank you all.